So you may be aware, you may not be aware that this form was actually updated March of 2023, and we've made a very specific change in Section 5 of this agreement that we're going to get to here in just a few short minutes. But I wanted to just start out with my disclaimer. Remember, I am not an attorney. I do not play one on TV. I am simply a broker in charge. I wanted to make sure that you have all the latest information on our South Carolina Association of Realtors forms. Again, we're going over the exclusive right to buy buyer agency contract form 130. So once again, I'm not an attorney. I may say something that you do not agree with, and if that is the case, please make sure that you talk to your specific broker in charge and make sure that you are filling this form out exactly the way that they want you to fill it out. Without further ado, let's get into the contract. We're going to look at Section 1, very easy section. Right here, the appointment of the broker. So right there in that first line, by this contract, that is where the buyer's names go. The contract appoints the broker in charge of the blank company. So that's going to be your company here at Berkshire Hathaway Home Services, C-Dan Joyner Realtors. This is not a marketing document. You can actually utilize BHHS C-Dan Joyner Realtors in that particular blank. You do not have to try to fit in Berkshire Hathaway Home Services, C-Dan Joyner Realtors. But whatever company you work for, that is where you put your company name. The rest of that is pretty self-explanatory. I want to just point out that it talks to the buyer specifically here. It says, buyer agrees to conduct all negotiations for the types of property described in Section 2 below through the broker and refer to broker all inquiries made to buyer about such properties from other brokers, salespersons, sellers, and others during the term of this contract. Let me stop right there. This is a very important section because a lot of times buyers will sign this and they may accidentally start talking to other real estate licensees, other brokers, salespeople, on-site salespersons. Make sure that you reiterate this to your buyers that when they're signing this document with you, it is like a marriage document. Have them talk to you about everything. Refer everything to you so that you can then perform on their behalf. Let's talk about that last line, negotiation. Negotiation as used in this agreement shall mean property. Look at that. Shown, negotiated, or even information requested by the buyer through the broker. That's what a negotiation means in this particular agreement. That is extremely important. When information is requested, property shown, the term negotiation means just that in this particular agreement. Let's move on to Section 2. Section 2 is called the purpose of the agency, and I want to make sure that everybody understands this is directly found within the Real Estate Code of Laws, Chapter 40-57 in our South Carolina Code of Laws. And it's very specific with what needs to be filled out here. Otherwise, if it's not filled out correctly, it does not meet the terms of the Real Estate Code. There needs to be a type, a general description, and approximate price range for this particular document to be valid between the brokerage and the buyer. You need to make sure that you check one of those boxes, either residential, commercial, industrial, vacant land, or other. You put a general description. A lot of people ask me, what in the world would I put there? General description could be 3-bedroom, 2-bath house, approximately 2,000 square feet to 2,600 square feet. That could be a general description. It doesn't have to be absolute, just a general description of what you're looking for. An approximate price range. If your buyer is going to pay between $300,000 and $350,000, that's what they're looking to pay, you can do an approximate there. The general location is not necessarily absolute for license law, but it is a term of this contract. So if you're going to be looking in Greenville County for a property, or Malden specifically, you can put the general location, or Greenville County, Anderson County, Spartanburg County, Lawrence County, you could put that general location there as well. Now, what happens if a buyer agency agreement is only being written for one particular property? You can put that address right there in the general location, put that address on that line so it is specific to that particular address, this buyer agency agreement. Preferred terms could be anything that you want. If somebody's looking to utilize you to help them buy with a VA loan or an FHA loan or through cash, you could put that there. And other types of terms, maybe they're Maybe they're looking for only properties that have a pool, a built-in pool, or on the lake. You can put that there, other terms. So that's just very general, but again, fill out as much as you can here, but make sure that the type, general description, and approximate price range are filled in. That will fulfill your South Carolina Code of Laws requirement in this document. Let's move on to Section 3, Broker's Duties. Section 3, Broker's Duties. This is a fairly long section, and I'm going to read a lot of it because I want to make sure you have a good understanding of it, especially if you're watching this video. You're probably a real estate agent watching this video trying to figure out how to utilize it. So let's look at it. The broker shall provide to buyer a meaningful explanation of agency and shall use broker's professional real estate knowledge and skills to represent the buyer in a diligent and effective manner and to locate property which is available for purchase or lease and suitable to the buyer. Let me stop right there. At the very first substantive conversation that you have with a buyer, you should be explaining the agency, South Carolina agency in South Carolina. That is real estate law, right? So very first substantive conversation. So it's already talking about, it just reiterates it that you're going to go over that with the buyer, that you're going to give them a meaningful explanation of it and to search diligently in an effective manner to locate a property for them. B, if the broker is not representing the seller, the broker shall represent solely the interest of the buyer in all negotiations and transactions regarding the acquisition of real property. Okay, that's pretty self-explanatory. You're going to be under single agency if you're not representing the seller in the transaction. It also goes on to say, and repudiate any agency or sub-agency relationship with the seller or the company representing the seller and shall not claim the sub-agency compensation offered to the selling broker in the multiple listing service. C, if the broker represents the seller as well as the buyer, that is considered dual agency, right? And in our state, you will fill out a disclosed dual agency form, which both the buyer and the seller will both sign. The broker shall not disclose to the buyer information obtained within the confidentiality and trust a fiduciary relationship with the seller, nor disclose to the seller information similarly obtained from the buyer without consent of the party. You need to maintain confidentiality at all times, especially in dual agency. D, the broker may represent other buyers who may be interested in the same property as the buyer. Okay, so if that happens, there is a multiple buyer disclosure in the South Carolina Association of Realtors forms. You will need to fill out one of those called a multiple buyer disclosure. Upon the termination or completion of this agreement, the broker shall keep confidential all information received during the course of this agreement, which was made confidential by written request or instruction from the client, except as provided for under South Carolina law. All right, let's move on to that second paragraph. Broker represents that the broker is duly licensed under the laws of South Carolina. As a real estate broker, broker will use his or her best efforts as a buyer's agent to locate property, the type described in Section 2 of this contract, and to negotiate an acceptance of any offer by buyer to purchase or lease such property. During the term of this contract, the broker will give buyer information describing and identifying properties that appear to broker to substantially meet the conditions set forth in Section 2. Understand something, let me go into a little bit further detail. Sometimes your general description may change. It may change, so you may have to update this document if your buyer decides to go a different route on a general description. So we'll move on to Section 4, Buyer's Duties. Section 4. Section 4 is called Buyer's Duties, or the buyer agrees to. I would strongly suggest when you are discussing this document with your buyers and going over this as you're explaining this to them, you really spend a good amount of time here, because if this contract is going to be violated in any way by the buyer, it's going to be here. This is where a lot of times we find that the buyer actually defaults on the buyer's agency contract. So let's go over this in pretty good detail. So A, in the bold letters there, work exclusively with broker and its affiliated licensees during the term of this agreement by, and it's got a few numbers after that. Now, work exclusively. That means the buyer is working solely with you as the buyer agent, okay? This is, like I said, I kind of describe this as a marriage contract. You guys are absolutely creating a contract together, and you work exclusively together. Number one, viewing any property, previewing, etc., only with broker or broker's designated representative and not with another real estate broker, salesperson, or seller. And Number 2, exclusively allowing broker or salesperson to identify property, negotiate for buyer, and otherwise to represent buyer. And 3, referring to broker all, not some, all inquiries received in any form from any other real estate broker or affiliated licensee. And number 4, see how it says and all of these things, not just one, not just two, and all these things. Holding broker, number 4, holding broker harmless from liability as a result of incomplete, inaccurate information provided to broker by the buyer or the seller. Because that can happen. We can get in false information from not only buyers, but we can get it from sellers as well. 5, holding the broker harmless from liability as a result of seller's failure to provide a complete seller's property condition disclosure statement. You do not know how many times buyers try to hold that against buyers' agents because a seller filled this out or filled it out inaccurately or did not fill it out completely. This is not our issue. That is the seller's issue. Number 6, indemnifying the broker against all claims, damages, losses, expenses, or liability arising from the handling of earnest money by anyone other than the broker. Remember, Berkshire Hathaway Home Services, Seed and Joiner Realtors no longer holds earnest money. That is going to be held by the escrow holder, most likely the closing attorney. But we do not hold earnest money. Just a reminder for Berkshire Hathaway Home Services, Seed and Joiner Realtors agents. Subsection B, assist the broker and its affiliated licensees in the process of identifying, negotiation, and contracting to purchase, lease, or otherwise acquire by, and then we got a few more numbers, providing the broker with reliable information, including financial information and written authorization to obtain verification of funds. The buyer is going to provide this to the broker so that they can, once they go to purchase or offer on a property, they can submit that along with the proper contractual documents or to a lender or whoever is necessary. That broker deems necessary for the performance of this agreement. And number 2, making himself or herself available to meet with broker and to see properties in order that the broker will be able to perform the promises of the broker's engagement. Okay, so a lot of times what we'll see is properties are coming up on the market and the agent is letting the buyers know, hey, this property came up, this is a hot property, it's available, and it comes to find out where the buyer's not available to go and preview the property, and then the property goes under contract and the buyer gets upset about it. This contract says the buyer needs to make themselves available in order to see those properties that are definitely hot on the market. Let's get on to subsection C. Provide broker and its affiliated licensees the following information. Number 1, general nature, location, and requirements of desired property, and the price range. Number 2, and other terms, conditions relating to desired property. Again, that's all up above in section 2. D, to authorize buyer's attorneys and the settlement agent to furnish to broker copies of the final settlement statement for the transaction prior to the closing date. Remember, the law says that the closing disclosure is supposed to be to both buyer and seller, and hopefully to the real estate agents 3 days before a closing. So that is right also in our buyer's agency agreement. You'll also notice there that there's 4 buyer lines for them to initial, and also a place for the broker to initial or the agent underneath the broker to initial. It doesn't necessarily have to be the broker in charge. It's you as the affiliated licensee to initial that as well. All right, section 5, the compensation of broker. This is where the biggest change was made in this contract in this latest revision. And so therefore, I am going to read the entire thing. We're going to spend some time on this so you guys have a great understanding of this. So number 5, compensation of broker says brokers' fees will be deemed earned. Look at that word, earned, when buyer is under contract to purchase any property presented by broker or negotiated by buyer. Remember what negotiated said on the very first page. So there's that word again, it's defined. This fee will be due and payable, look, at closing or upon buyer's default, or upon buyer's default. So they need to make sure if they default on this for any reason, they theoretically, by this contract, owe you that fee that is right below this, this section. If buyer defaults, the total compensation that would have been due broker will be due and payable immediately in cash from the buyer. In consideration of the services performed by broker under the terms of this contract, buyer agrees to pay broker the following fees, and it says check and initial all applicable sections. Buyer shall pay broker a brokerage fee of dollar amount or a percentage. Okay, so for the purposes of this video, I am going to use X number percentage. I'm not going to give a percentage, just X number. There needs to be a number in at least the dollar amount, which could be a flat fee if the buyer's agent is charging a flat fee, or a percentage. What you cannot have here, and I stress this, you cannot have X through X plus. So for example, you can't have 2 through 4%. It has to be one percentage amount. Whatever number your brokerage wants you to put there, or your broker in charge wants you to put there. So one number of the purchase or total lease price, renewable if applicable, of any property purchased or leased by the buyer, including for sale by owner properties. Any fees paid by the seller or seller's agent to broker shall be credited against the brokerage fee. So in other words, if they're going to be paid through the MLS, it's going to be credited against whatever number is in the two blanks above. Broker shall use their best efforts to obtain payment of the brokerage fee out of the transaction, but buyer shall have the obligation to pay broker the brokerage fee set forth in this contract if broker cannot obtain payment of such fee out of the transaction. Now, most of the time, this is not an issue, okay? Most of the time, whatever is being requested is a lot of time is in the multiple listing service with the amount that the buyer's agent is asking for, and this is not even an issue. But I get the question all the time, well, what if you put X number in the percentage amount and what's being offered in the MLS is less than what you are actually charging? Again, this document does say that the buyer shall have the obligation to pay the brokerage fee if they cannot obtain it out of the transaction. So if the MLS or the for sale by owner is only providing X amount and it's not quite hitting what you're charging, the buyer shall have the obligation to pay that deficit. Now, I get the question a lot, well, what if you don't want to go back and charge your buyer the difference? Well, that is something that you need to ask your broker in charge if you're able to do that, because remember, an agent or affiliated licensee cannot make that determination on behalf of a brokerage or a broker in charge. That is something that your broker in charge will need to allow you to do, or give you attorney-approved language to say whatever the broker in charge wants to say to the buyer, that they will not be responsible for that particular deficit of the fee. So make sure you get with your broker in charge if what is being offered is less than what you are being charged here. In the event that the compensation being offered to broker from the transaction is greater than the above dollar amounts or percentage amounts, including any bonuses, the buyer agrees that the greater amount shall become the new amended brokerage fee without modification to this agreement unless otherwise agreed to in Section 17. Now, what does this mean? If you're charging X amount and the seller or the for sale by owner is actually paying more than that amount, that you do not have to make any changes to this document. That amount now becomes the new brokerage fee automatically with this particular paragraph. The broker will disclose any change to the brokerage fee above, including any and all bonuses being offered to broker in writing to the buyer. If within blank days after the expiration of this contract, buyer purchases or lease any property which broker has negotiated, there's that word again, negotiated, during the term of this contract, the buyer will pay broker the brokerage fee stated above. So hopefully that gives you a good understanding of this particular paragraph and change. And again, there's certain things that you may want to talk to your broker in charge about. If again, what you're charging is, if what's being offered in the MLS or the for sale by owner is less than what you're charging, get with your broker in charge, find out how they want to handle that. Or there could be some other language that's written by an attorney that you could put in section 17 that will allow you as the agent to not have the buyer have the obligation to pay that deficit. Again, completely up to your brokerage and broker in charge. Please see them for that. Hopefully that explains that. And as you can see, the box B there, the buyer will pay the broker the following initial all that apply. Okay, so if there's other fees involved, example, retainer fees, service fees, we can talk about those retainer fees. I don't see these a lot, but it's in there. If you, as an agent and your brokerage allows this, the blank amount will be due and payable upon the signing of this contract. The fee shall or shall not be credited against the brokerage fee. That is extremely, extremely important. That is for you to keep up with. So if you're charging one amount in the section above, in A, if you're charging a certain percentage or a certain dollar amount and somebody pays you a retainer fee, you as the agent need to make sure if that's supposed to be credited against that brokerage fee above, you need to make sure that at closing, that if your brokerage is holding that money or that's already been paid to you, that is credited against that brokerage fee and they don't pay that fee again. The service fee, the buyer shall pay broker a service fee of blank dollars to be paid no later than blank calendar days of the signing of this contract, regardless of whether or not the buyer purchases any property. And look at all these boxes. The service fee shall be the only fee due broker from buyer under the terms of this contract. This service fee shall be credited against the brokerage fee described above and shall be kept by the broker whether or not a brokerage fee is earned. This service fee shall be credited against the brokerage fee described above and shall be kept by broker whether or not a brokerage fee is earned unless buyers enters into a purchase and sale agreement. In the event that the buyer enters into a purchase and sale agreement, buyer and broker agree that the above service fee will be credited against the brokerage fee in section A above. So I don't see a lot of these service fees being utilized. It's not that they can't be, I just don't see a lot of them. Check with your broker in charge if they want to allow these or how you guys want to work that. But again, the biggest thing I can stress, if you're going to charge a service fee or retainer fee, make sure that it's either credited against or not credited against the service fee charged in section A above in broker compensation. We're going to terminate that section. We're going to move on to section 6, the term of the agency. Section 6, term of agency. The broker's authority to act as a buyer's exclusive agent under the terms of this contract shall begin on calendar date and shall end at 11:59 p.m. on calendar date. This is very self-explanatory. It's very easy. You've got to have beginning and end dates to a contract. Starting of the contract, ending of the contract. There is no standard of how long these agency agreements shall be. This could be signed on a Friday afternoon and end on Sunday night at 11:59 because a buyer comes in from out of town and they only want to work with you for the weekend. I've seen it happen. Can it happen? Yes, because this allows it to happen. I've seen these from 1 month, 3 months, 6 months. I've seen them up to a year. Just make sure you have a beginning date and end date in section 6, the term of the agency. Section 7, consent to disclosed dual agency and designated agency. The very first line talks about the explanation of the types of agency. If you recall, back up in section 3, we talked about you as the real estate licensee at the first practical and substantive contact with the buyer, you need to provide that explanation, the meaningful explanation of the types of agency that your brokerage provides and what types of agency you're going to provide and what is dual agency, what's designated agency, what's disclosed, what's single agency, and all that. Okay, so they're going to initial that line there. Then it goes on to say, buyer acknowledges that after entering into this written agency contract, the agent might request a modification in order to act as a dual agent or a designated agent in a specific transaction if asked. The reason why that says that is because you've got two different sections here. You got two sections for dual agency and two sections for designated agency. The first line there, or line number 2, I should say, is permission to act as a dual agency will not be considered at all. There are some buyers that say, no, sir, no, ma'am, no way, no how. You are representing me solely. There will be no dual agency whatsoever. That's up to a buyer. It's completely up to a buyer. They can initial that. However, if the buyer says, listen, it's okay, I'll decide at the time whether dual agency is going to be okay. And at that time, we'll give the buyer the opportunity to say yay or nay. Same thing with designated agency. Permission to act as a designated agency will not be considered, or it may be considered at the time. So once again, look at those, decide have the buyer decide what is good for them, and initial those specific lines that meet their criteria. Once again, at the bottom of the page, don't forget the initials for the buyers, and also the real estate associated licensee under the broker have read this page. Going on to Section 8, other potential buyers. Section 8, other potential buyers. This section is pretty easy to understand. It says the buyer understands that other potential buyers have entered into similar agency contracts with you as a real estate licensee or brokerage, and they may involve the purchase or lease through the broker of the same or similar property or properties as the buyer is attempting to purchase or lease. So the buyer consents to broker's representation of such other buyers. Broker agrees not to give buyers confidential information to such other buyers. Obviously, you have to maintain confidentiality, and not to give such other buyers confidential information to buyer unless otherwise agreed. We all know confidentiality is of utmost importance. If you're working with other buyers, you do not talk about other buyers' confidential information to your other buyer clients. Simple as that. Let's move on to Section 9, Indemnification of the broker. All right, Section 9, Indemnification of the broker. Buyer promises to disclose to broker whether buyer has signed any agency agreement with any other broker or has been given prior information about any property that is subject to this contract by any other broker or salesperson, or has previously been shown any such property by any other broker or salesperson. Stop right there. This is massive. This is huge, because we hear this all the time. You hear agents saying to buyers, or you hear stories, well, I asked the buyer, did they sign anything with the agent that they were talking to? And buyers typically say no. This is where you need to really concentrate with your buyer when you're going over this document. Hey, listen, if something happens and you sign another agreement with somebody, you need to tell me now before you sign this one. Let's make sure that you did not sign another agreement, so we don't have two buyer's agency agreements conflicting with one another. Okay? And remember, the Code of Ethics also says that you as a real estate licensee need to make sure that you do your due diligence to dissolve the fact that your buyer has not signed another buyer agency agreement with another brokerage. So if the buyer fails to tell the broker about such other brokers or salesperson's involvement, and broker incurs any loss or damage as a result of any claim being brought against him on account of such involvement due to no fault of the broker, then buyer shall pay broker all such losses and damages incurred by broker because of such claim. That right there, ladies and gentlemen, that is major. So please make sure you reiterate this to your buyer. Please, Mr. and Mrs. Buyer, have you signed anything? Are you sure? If you did sign something, do you have copies of it? Who did you sign it with? What company? Let's make sure we get a copy of that, so you can just, completely dissolve, or the buyer can completely dissolve any other arrangements or documentation or contracts with other brokerages with that particular broker in charge, if they choose to do so. But they're going to have to talk with that broker in charge and that brokerage about that. That is not your responsibility. That is on the buyer to do that. And you are not to discuss how a buyer can get out of a contract. That is an absolute no-no. If you find out that one of your buyers has signed a buyer's agency agreement, it is your responsibility to send that buyer back to the broker in charge, back to the brokerage that they signed with, and talk to that brokerage. This is a legal and binding contract. So please make sure you do that. Moving on to Section 10, Disclosure of Buyer's Identity, Confidentiality. It's really simple. The broker does or does not have the buyer's permission to disclose the buyer's identity to all property owners and other third parties. The buyer is advised of the possibility that seller or seller's agent may not treat the existence, terms, or conditions of offers as confidential unless confidentiality is required by law, regulation, or by confidentiality agreement to the parties. Understand, once your buyer submits an offer, that seller is under no obligation to keep that confidential at all. You as an agent are. You're supposed to keep everything confidential. But this talks about whether you can disclose the buyer's identity. Now, I will say in residential real estate, most of the time we see that the buyers give the buyer's agent permission to disclose their identity. Sometimes in commercial real estate, you will see that they do not have permission and the buyer may be confidential. But we just don't see this in residential. Most of the time you will check, does have the buyer's permission to disclose the buyer's identity. Again, I've only seen this one time in 17 years. It did not work out well for the buyer that tried to have their identity confidential, because the seller basically said, hey, I like your offer, but I'm going to reject it unless you tell me who you are. And so the buyer ended up having to just come forth and come clean with who they were. And they were able to work it out, but that's exactly how it worked in residential. So again, does have the buyer's permission most of the time, you'll see that. Section 11, the broker liability limitation. Obviously you could see that this one paragraph is in italics. This is a very difficult paragraph to explain a lot of times to buyers. I'm going to read the entire thing, then I'm going to give you the layman's terms about it. All right. So it says, buyer agrees, broker provided buyer with benefits, services, assistance, and value in bringing about this contract. In consideration and recognition of the risks, rewards, compensation, and benefits arising from this transaction to broker, buyer agrees that he shall pay broker's attorney's fees and that broker shall not be liable to buyer in an amount exceeding that broker's compensation by reason of any act or omission, including negligence, misrepresentation, errors and omission, or breach of undertaking, except for intentional or willful acts. I know that's a lot, bear with me. This limitation shall apply regardless of the cause of action or legal theory asserted against the broker, unless the claim is for an intentional or willful act. This limitation of liability shall apply to all claims, losses, costs, damages, or claimed expenses of any nature from any cause except intentional or willful acts, so that the total liability of the broker shall not exceed the amount set forth herein. The buyer will indemnify and hold harmless and pay attorney's fees for broker from breach of contract, any negligent or intentional acts or omissions by any parties, inspectors, professional service providers, contractors, etc., including any introduced or recommended by the broker. Buyer agrees that there is a valid and sufficient consideration for this limitation of liability and that broker is the intended third-party beneficiary of this provision. Now, that is a lot of words and it can be very difficult to understand. Basically, what this is saying is that if the buyer finds you made a mistake, you did an error, you admitted something, there was some misrepresentation or some negligence on your behalf, anything outside of intentional willful acts, okay, that if the buyer decides to go ahead and bring a legal suit against you, that the buyer is responsible to pay all of your attorney's fees, but they're only going to be able to get what you would have made in the transaction if the transaction would have come to a close. If you were to make a certain dollar amount, this section says they're only able to go after that particular amount of money, what you would have made. Now, all bets are off if you do something intentional or willful, okay? Obviously, you're looking at other problems as far as crimes against the state or against the buyer at that point. Intentional or willful acts are not part of this. And obviously, there's no level of what they can go after if it's intentional or willful. Now, this also does say that they hold you not accountable for people that you, or vendors that you say, or that you provide to them to help in the transaction. For example, home inspectors or roof inspectors or attorneys or lenders or whoever, professional service providers, that if those people do something wrong, that they hold you not liable. They will not hold you liable for their acts as well. So again, that is the biggest thing about this particular paragraph. I understand that it can cause a lot of buyers some heartburn, especially when it says they'll pay your attorney's fees and things like that. That's all going to be worked out in the court. and find, when it comes to their attorney and your attorney or the brokerage's attorney, but that's what this paragraph says. And remember, the State of South Carolina Association of Realtors, thank God for them. They have these forms to benefit and to protect us as the real estate licensees. And there you go. That's the paragraph. That's what it means in layman's terms. Let's move on to non-discrimination. Section 12, non-discrimination. The broker and buyer agree that all actions carried out under this contract shall be in full compliance with local, state, and federal fair housing laws against discrimination on the basis of race, creed, color, religion, national origin, sex, familial status, marital status, age, or disabilities. In other words, layman's terms, you as a real estate licensee, associated licensee, real estate agent, realtor, broker, you cannot discriminate at all whatsoever. We do not put up with it. Nobody should put up with discrimination. That's what Section 12 says. That is about as plain and simple as I can explain that. Do not discriminate, period. Section 13, professional counsel. Buyer acknowledges that broker is being retained solely as a real estate agent and not as an attorney, tax advisor, lender, appraiser, surveyor, structural engineer, home inspector, or other professional service provider. The buyer agrees to seek professional advice concerning the condition of the property, legal, tax, and other professional service matters. Let me help you here. I love the term stay in your lane. As a matter of fact, I got a whole blog post written about it. My pastor basically taught me this, and it has helped me in my career. I want it to help you. Stay in your lane. This is the stay in your lane clause. You are a real estate agent. You are not a home inspector. You're not a tax accountant. You are not this, or that. Stay in your lane. If somebody needs tax advice, please help them find maybe someone to talk about their taxes, a tax advisor. If somebody needs professional advice on their home inspection, you're obviously going to help them find a home inspector. If they need legal advice, give them an attorney. Please stay in your lane. Only do what you're supposed to do as a real estate agent. Section 14, mediation clause. Any dispute or claim arising out of or relating to this agreement, the breach of this agreement, or the services provided in relation to this agreement shall be submitted to mediation in accordance with the rules and procedures of the dispute resolution system of the National Association of Realtors. Let me stop right there. It says shall be submitted. Most of the time, buyers and sellers are not going to go through mediation. They're just not. When there's a problem, when there's a dispute, a seller, a buyer, they're going to just go right to an attorney. They're going to bypass mediation. Now, I will say this about the state of South Carolina. Once that happens, mediation has to take place in the state of South Carolina, period. If something goes to trial attorneys, mediation is going to take place before that dispute ever sees a courtroom. Disputes shall include representations made by buyer or broker in connection with the services to which this agreement pertains, including without limitation allegations of concealment, misrepresentation, negligence, and or fraud. So basically what they're saying is that you can mediate about just about anything that happens during the confines of this contract and during the terms of this contract about these things. So limitation, allegations, concealment, misrepresentation, negligence, or fraud. Any agreement signed by the parties pursuant to the mediation conference shall be binding, it says. This mediation clause shall survive for a period of 120 days after the date of the closing. So if a buyer or a broker has a problem and they want to mediate, remember this clause. It says you got 120 days to file this. Again, I don't see a lot of mediation. Most of the time people just talk to their own attorneys and it goes that route, but it's there for a reason to save buyers, brokers, and sellers some money. Section 15, sex offender criminal information. This is very important here. It's very black and white. It says the buyer agrees that broker is not responsible for obtaining or disclosing information in the South Carolina Sex Offender Registry, and no course, none, zilch, nada, no course of action may be brought against the broker for failure to obtain or disclose sex information or criminal information. Buyer agrees that they have the sole responsibility to obtain their own sex offender, death, psychological stigma, clandestine laboratory, and crime information from sources, for example, like law enforcement, private investigators, the internet. The buyer may obtain information about the sex offender registry and persons registered with the registry by contacting the local county sheriff or other appropriate law enforcement officials. Remember I said earlier, stay in your lane? This is one of those. Stay in your lane. It is not your responsibility. Don't look it up. Just refer them to law enforcement if they are concerned about sex offenders or the sex offender registry or death or psychological stigmas. Okay? Just stay away from this. It's not your responsibility. Section 16, the entire binding agreement. This written instrument, the contract, the document, including the additional terms and conditions set forth on the reverse, expresses the entire agreement and all promises, covenants, and warranties between the buyer and the broker. It can be changed only by a subsequently written instrument signed by both parties. What does that mean? It means an addendum. You can change this contract with South Carolina South Carolina Association of Realtors Form 390, the Blake Addendum. On the top of that, it says other, and you can just put exclusive right to buy, and you can change this document however you see fit or however your buyer wants you to change it. Okay? But this form is the agreement with how you, as the buyer agent, get compensated. This is a legal and binding agreement, okay? So make sure it is signed, it is proper, it is dated, and everybody knows this is the legal and binding agreement. Whatever happens needs to be found within the confines of this contract, just like an agreement to buy and sell. Section 17, contingencies. Now, as you can see, there's 3 lines here. There's no contingencies. That means that you can write in whatever contingencies you may see fit. Now, I get asked a lot, what would be a contingency? Well, it could be that this buyer's agency agreement is contingent upon the fact of the buyer moving from XYZ state to South Carolina because they are being hired by XYZ company. And if they do not get hired, the buyer's agency agreement becomes null and void. It's contingent upon them getting hired. Okay? That could be one contingency. I'm sure there's several others that you can think of. You can also have other attorney-approved language if whatever happens in Section 5, your attorney says, hey, we're going to do this with the compensation. Okay, so you would put that here as well. So whatever your broker in charge says for a contingency, you can also write there. If you have attorney-approved language, preferably, but that's where any other contingencies would go. That's pretty self-explanatory. Section 18, I can't believe I'm even saying this word in 2023, but facsimile and other electronic means. It even sounds funny coming off my tongue, facsimile. The parties agree that this agreement may be communicated by use of a fax or other secure electronic means, including but not limited to electronic mail. That's an email, by the way. Electronic mail and the internet, and the signatures, initials, and handwritten or typewritten modifications to any of the foregoing shall be deemed to be valid and binding upon the parties, as if the original signatures, initials, and handwritten or typewritten modifications were present on the documents in the handwriting of each party. What is this saying? You can utilize e-signature software. It's all legal and binding, whether it's faxed, email, sent through the internet, carrier pigeon, hand delivered, whatever. If it's signed in ink, if it's signed through electronic means, it's all legal. Okay, they're just the same as if they were signed and handwritten in front of each and every person and party. So, just want to let you know, we still use fax. If you need to use a carrier pigeon, you can do that as well. Let's go on to Section 19, surveillance. Number 19, surveillance. Buyers advise that properties they enter may have both audio and video surveillance. The broker advises the buyer to be aware of possible surveillance and conduct any and all communications about the potential property off-site. Now, a lot of times buyers will forget this, okay? You'll go up to the front door of a property. There'll be a Ring doorbell. Buyers are talking. Maybe the buyer's agent is talking, and they're already talking about what they see on the outside of the property. Let me make this very perfectly clear. Do not say anything about the property on site. In any property, take all conversation off site about the property. A lot of people have video and audio surveillance in their home nowadays. You do not want to have that be a detriment to your negotiation or hinder your offer in any way. So just be aware, surveillance is everywhere nowadays. So just make sure that you do not talk on site. Hopefully that helps. And this last big bold section here just reminds you this is a legally binding agreement. The buyer shall seek further assistance if the contents are not understood. Buyer and broker acknowledges receipt of a copy of this agreement and copy of the South Carolina Disclosure of Real Estate Brokerage Relationships form. That's 3 times it's mentioned in this document. Buyer agrees to receive communications from broker at the email address, phone, and look at that, fax number listed below. Fill out as much information here as possible. Don't just have them sign and date, okay? Sign, date, time, put the email address, put the phone number. If they have a fax number, put it there. Make sure that you fill out as much information as possible. Make sure you put their address on there. The broker in charge or another agent may need to get a hold of the buyer. So we need to have as much information as possible. So fill out this in its entirety. Don't be lazy, fill it out. Also, if you put the buyer's address in there, you can also make sure that you send a thank you card to them right after signing this so you have their home address. So you know exactly where to go. So that's just a little tip there. Send a thank you card after they sign this and how much you appreciate them working with you. Make sure you signed it, put your company name there, and put the your name and that's your signature right there. Put your company and also date and time that. All right. Make sure that everybody initials and sign or initials the bottom there with all the initial blanks, and make sure that you initial all the lines. All right, that concludes the buyer's agency agreement. Hopefully that has explained everything in detail. Again, here's my disclaimer: not an attorney. I do not play one on TV. If you have any legal questions, please make sure to contact your attorney of choice. You may also contact South Carolina Association of Realtors. Also, let me make sure I tell you this. The South Carolina Association of Realtors did not affiliate with me to do these training videos whatsoever. And again, I'm doing this as a benefit to the agents of Berkshire Hathaway Home Services, Seat and Joiner Realtors, as well as other agents in South Carolina and other associated licensees of South Carolina. So if there's any question whatsoever, make sure you get with your broker in charge. Contact the legal department of the South Carolina Association of Realtors just to make sure that what I'm saying is true. If you have any questions whatsoever, again, get with your broker in charge, because I am errant, I am not God, and sometimes I can make mistakes. So if you see any mistakes in here, please let me know. Be more than happy to correct them. I think I got everything pretty well good to go, and hopefully this helps you maintain your good contracts with good buyers and make sure you're doing good real estate. Have a great day, everybody. Take care.